still be unreasonable?
Keith Locke.
Thank you, Mr Chair. I thank the Attorney-General for those comments, and I do appreciate that the reference to the Bill of Rights has been put in the bill in 3D, but I think that it is still in conflict with the clause that I have an amendment on to before the House to omit 5A, because the way I read 5A, it is in direct contravention to the Bill of Rights, because the fundamental principle, as I indicated in my initial speech, was that people have to be tried, found guilty, conduct their appeals, etc., on the law as it applied at the time. And the Supreme Court, in relation to covert video surveillance involving trespass, has indicated that that was unlawful at the time and unlawful in any previous trial. So that if, for example, just a hypothetical example, the entire evidence against somebody convicted, or the absolutely primary evidence even, was on the basis of covert video surveillance involving trespass, now that the Supreme Court has ruled this year, somebody who was convicted, say, a couple of years ago on that basis could come back for an appeal. Potentially, they mightn't succeed, and there's all the other issues involved in appeals. But we should not, as a Parliament, rule out their right to apply the law applying at the time. And this is against the International Covenant of Civil and Political Rights, and people like Tony Ellis did in their submission, written and oral submissions to the Select Committee, indicate this. And Tony Ellis has taken appeals to the UN Human Rights Commission. I think he's won committee and won 3 of them on such similar substantive legal grounds where the New Zealand jurisdiction seems to be out of odds with international law. So, you know, I think I was right to put in my speech that we could potentially face a challenge on the international bodies if somebody did get an appeal denied on that basis. I do take the other point he made about 5.2, that the surveillance is not in and of itself, does not in and of itself render a search unlawful. It's similar to the point I made in my speech. I emphasise, and Charles Chauvel and David Parker wrong here, that the Green Party is not against covert video surveillance with the proper controls. What the whole issue here today in this bill is what the Supreme Court dealt with, covert video surveillance involving trespass, not without trespass. And I totally agree that, and I said in my speech, and it's quite clear, that if the police and our agency engage in covert video surveillance without trespass, then they're still subject to a test which they might succeed on or they might not, about whether that was reasonable in terms of Section 21 of the Bill of Rights Act. And clearly, and we had instances of this in the Select Committee, if the camera is just keeping an eye on someone's front gate, it's a camera in the street, covert, but checking who's going to and from a P-lab, focused on the front gate, that wouldn't be considered unreasonable in most cases, so they would get away with it. If it was a camera high up on a tree and people thought they were in a neighbouring property and people thought they were in private space, they were in there, it was focused through their bedroom or their backyard and they were doing naughty things in their backyard or whatever, it would be considered unreasonable and maybe ruled out by the court. So that is why I said this bill is a bill looking for a problem, because 99% of the surveillance that the police are doing now is covert video surveillance without trespass, subject to the Bill of Rights already, subject to the reasonableness criterion, and even the material collected unlawfully is still subject to the Section 30 of the Evidence Act, and it can be included if the crime, usually if the crime is deemed serious enough. So there's all of these fallback positions that in the existing law without this bill, so that we don't actually need this particular bill. And the other thing, of course, and this, Mr Speaker, this did come up at the Select Committee, and the Criminal Bar Association made the point in particular that in most cases the case doesn't turn on the video evidence. There might be a little bit of video evidence or photographic evidence or whatever, but it turns on all sorts of other things. So all I'm saying is that they've got so many fallbacks, the police, in prosecuting a case, even when they're using unlawful evidence, that is trespassery evidence. They've got the Evidence Act Section 30 that can rule the evidence in. They've got the reasonableness side of it, that as long as they cover that, and also they've got a whole pile of other evidence. And it's probable, in my opinion, that most of the covert video surveillance without trespass is just sort of working out who's involved in a PLAB or whatever. And then they've got piles of other evidence, including all the evidence they now get, rightly or wrongly, from intercepting electronic communications, texts. And if you look at the Operation 8 case, there was masses of electronic interception and other forms of surveillance material that they presumably were trying to hang their case on in certain cases. And the Supreme Court's decision in Operation 8 is an interesting illustration in that the Supreme Court allowed the use of Section 30, the Evidence Act, and said that, yes, the evidence collected against the 4 remaining on the organised criminal group charge, that evidence was collected unlawfully, but we're going to allow it in that case to continue because they defined organised criminal group and the other charges as sufficiently serious enough. So that's why I say it's very hard to argue for this. And I think it is important, because of the conflict between the Bill of Rights provision in the Act and the fact that you can't, under Section under 5A, you can't use the fact that evidence on you, even though it was illegally collected, that is covert video surveillance involving trespass, that you're not allowed to use that in an appeal. That is quite unjust, and I think it is important that parties, and I think it's going to come under quite a bit of criticism from the law profession, because it is a retrospective provision which is generally unacceptable, and it is in conflict with the Bill of Rights Act. Generally on the Supreme Court, it is our highest court, and we shouldn't treat its decisions lightly. It hasn't got quite the strength of the US Supreme Court, where to overthrow a US Supreme Court decision you've got to have, 2/3 of 2 houses and all kinds of things, and things like their abortion decision back in 1973, I think, still stands because, even though there's quite a big religious right and all the rest of it, they can't, overcome that. But it isn't respecting the Supreme Court when we see the police deliberately breaking the law, as the Chief Justice said in the Operation 8 case. They don't get any penalty whatsoever, so then a certain disrespect for the law is generated. And some of the submissions, particularly I think from Tony Ellis, in quoting learned judges and whatnot on that it creates a disrespect for the law when the state breaks the law. There's no penalty, then the law changes, some retrospectivity is put in there. And it's it is true that ultimately in this system we have here, Parliament is supreme, but we must always guard the sanctity, or whatever you want to call it, of the judicial system and of the court system, and particularly of the Supreme Court. And I think rushing this legislation through is not achieving that. I also wanted to talk a bit about the extension of these powers beyond the police, because that has been too little covered, both in the political debate and in the media coverage of it. But I went through the search powers of various other agencies that have search powers, such as Fisheries, Internal Affairs, Commerce, Customs, etc. And all of these agencies for the next 6 months, until we deal with the search and surveillance bill, will have these powers to leave covert video cameras on private property.
Mr. Chair.
Rauhiwa Katani.
Thank you, Mr.